Let me just, okay, there we go. Is your screen still blank?
No, your stop share screen went away. You don't have any slides up.
Okay. All right, there we go. Let me see if I can do this one more time.
Okay.
Did you get a black screen again?
I did.
Yeah. Zoom is requiring something of me. Um, okay, let's just continue on with it.
That's fine.
And we'll go forth from there. Because I know people like to see who they're talking to or who is talking as well.
Okay.
Um, but I'll figure this out as we go. I'm sorry for the interruption, but continue.
That's okay. So heirs property often occurs when a property owner dies intestate, meaning without a will or an estate plan providing ownership, leaving the property to all surviving descendants. When this happened, the state's intestacy laws govern the inheritance of the decedent's property. However, it can also be created by transferring it by will or by deed to more than one descendant as jointly owned property. The heirs who inherit the property jointly own it, having an undivided interest. So it's important for us to start now. Start the conversations right now. Start it with our elders as soon as possible and make sure to keep a family tree. Document, 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 and keep the family tree. That's very important. One of the things that I do is I do a little the family tree. I have to help do the research, and sometimes that can be very difficult. So especially for Black people, that is extremely um, difficult because some records are not there or they were destroyed and it's hard to figure out. And so it's best for us to make sure we keep a family tree, start the conversation now, okay? What are some of the causes of heirs property? Limited access to education on the consequences of its inadequate estate planning, limited access to legal resources, financial barriers for legal resources, competing priorities. Why competing priorities? Because we tend to put a lot of things before um, doing estate planning or creating a will or whatever we need to do. We've moved away, we've started a family, we have children, and all these things start to happen, and we put dealing with our assets on the back burner. Common threats to heirs property: partition sale, foreclosure sales, inadequate estate planning, no estate plan at all, fractionated interest, owning, being left owning one thing with multiple people. Challenges to owning heirs property: an increased risk in involuntary land loss through partition by sale, adverse possession, or tax auction. Um, Adverse possession. I know people have probably heard the common term of squatters' rights, squatters. Okay, that's a form of adverse possession. You're not paying attention to your land. You may not even know you own the land. You have not identified that this property belongs to somebody. Someone moves onto that property, they stay and make it home for a statutory period of time without any interruptions. And then they can say, hey, well, I own this land. Tax auctions, you're not paying attention. You're used to your uncle or your grandmother or whoever paying the taxes. You're not paying attention. You don't pay the taxes on the property. And then the government comes in, they take the property and auction the property off. Inability to undertake a mortgage or a lease. It is very difficult to get a mortgage if your property has heirs property ownership, because you can't identify who really owns it. Difficulty obtaining federal assistance like USDA programs or FEMA support after a natural disaster. USDA has kind of worked hard to kind of soften some of those barriers so you can get a farm number. FEMA is working to soften some of the barriers to being able to get natural disaster assistance. But all in all, it can be very difficult. And inability to insure property. And it can be very difficult to insure property when you can't identify who the rightful owners are, or all of the rightful owners. All you need is a will. I call it my myth buster. I've heard it a bunch. Oh, I just get a will. They got those documents I can fill in online. Oh, I can write my own will. Okay. So we're going to work on that conversation tonight. What is estate planning and why is it important? The process of evaluating your assets, determining the best tools to transfer them to your desired heirs upon death, and executing the relevant documents. Estate planning is a crucial aspect of financial management and end-of-life decisions that is relevant to every single individual, regardless of their age, income level, or family situation. We already do some estate planning without realizing it. When you open that first checking account, if you have got that teenage kid that is getting ready to go off to college and they're opening their first account and have money in the bank, and you say, well, wait, what if something happens? What happens to my money? Well, you put a beneficiary on the account, or some people call it a pay on death designee on the account. They don't co-own the account. They're not a joint account holder. But if something happens and you die, then that person will benefit after your death. So we do little things like that. We sign up for life insurance on a job. We designate, hey, who's the beneficiary on that? So we're already taking some steps toward estate planning. We're not just diving into it as deep as we need to. And we need to start that conversation. Comparing wills and trust. There are a few differences between wills and trust that we're going to go over, just some basic, just to kind of touch over it a little bit. A will is a legal document that determines how property and assets will be distributed after death. It does not take effect until after death. It's usually cheaper than getting a trust done. The disadvantage is there are probate costs associated with a will, and there can be potential challenges to the validity of a will.
Andrea, do you want to share your screen? Do you want to attempt to share your screen, or you're good?
I'm good.
Okay.
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 Mhm.
Okay.
A trust. A trust is a legal, it's a legal device that creates a responsible relationship between what we call a trustee and we have beneficiaries, okay? The trustee gets to make the final decisions and is responsible for paying taxes, okay? You can assign yourself. You can assign yourself to be the trustee, and whatever you're doing it for the benefit of the beneficiaries. So that means you're alive. You can do this and take part in this. The advantages of a trust is it's just an organized form of decision making, especially when you have heirs property management. A disadvantage is that a trust usually is more expensive to set up than a will. So if you need something inexpensive, a lot quicker to do, a will is an option for you. However, Here's again why it's important for us to start saying the word estate planning. All you need is an estate plan instead of all you need is a will, because every family dynamic is different and they have different situations. So you may get in and talk to a licensed attorney and discover, hey, maybe I want to do a limited liability company or establish a corporation. This may be better for my family. Probe additional estate documents, such as a living will and a healthcare directive. This is a legal document that expresses your preferences regarding life-sustaining treatment and allows another person to make healthcare end of life decisions for you. Or power of attorney. It's a legal document that allows another person to make financial decisions on your behalf. No longer valid after death, okay? So, or you may get in there and get to talking and find out, oh, there's a such thing as a springing power of attorney, means it doesn't spring into effect until certain requirements are met. Oh, okay. That is the importance of us discussing estate plans. Or, oh, I got this teenage kid who's in college and something may happen and I may need to be the one to pay the bills or access his records or her records. Oh, I need a power of attorney to be able to do that. Certain deeds. It depends on your state. For example, in Alabama, we have what's a life estate deed. It means I own this property for life, and upon my death, it will transfer automatically to whoever I designate it to go to. So these are very important things that we need to start looking at as part of our estate plan. A will by itself may not be the only thing that my family may need. So you say, hey, how do I select attorney? How do I pick someone to talk to about this? Well, look for the appropriate experience. Look for someone that's experienced in estate planning or real property or probate matters or business associations, such as setting up a business like a LLC or a corporation. You want to also look at recommendations from people, recommendations from someone else that considers the attorney to be competent counsel. A good example is through my membership with the Federation of Southern Cooperatives. They have a referral list. So they have worked with these people or had some kind of connection with these attorneys, and they know that the attorney is someone who has the appropriate experience. Willing to explain the costs for every single stage. Someone who's willing to talk to you about the cost from beginning to end, or will tell you, okay, you're going to have to pay for a title abstract or a title opinion. And what's a title abstract? Well, I can tell you from personal experience, a title abstract is very important. Even though my grandparents purchased their property in 1940, the title abstract reveals things like if there was ever a boundary dispute, or if there are liens on the property because you own it with all of these other people and you don't know what's going on in their personal lives. So that is very, very important. Some effects of inadequate estate planning. No estate plan creates heirs property, places limitations on the landowners and the community. There are restrictions. There's no autonomy. There are restrictions on how the land is managed and developed, can affect community tax gains and improvements, could lead to partition and tax foreclosure sales. Essentially, it makes clearing title vital to avoid legal loss. Partition sales. Any co-tenant may petition the court for a partition. While partition in kind is the preferred policy, courts often grant partition by sale. which can lead to an auction of the property to the highest bidder, who will own the property outright. Frequently, families are unable to compete with wealthy non-family bidders. An example of this, I'm sure that you've seen documentaries on YouTube. They come on often on television. Are you reading about them in the paper? Sometimes one co-tenant will sell to a wealthy developer. That developer will then now co-own the property with everyone else, and they will jointly own it. And then the developer will go to court for a petition for sale, and then they're able to buy out all of the other family members because they can afford it, and then they will end up owning all of the property. That's an example of a petition for sale. Petition in kind is when the family can get together and decide, okay, I'm going to take the part in the back by the creek. You're going to take the open fields, and I'm going to take the part with the trees because I don't live here and I'm not here all the time, okay? And then you're going to get surveys, and then you're going to get new deeds identifying that you own what part of the land. That's an example of what a partition in kind is, okay? Alabama has adopted the UPHPA, which is the Uniform Partition of Heirs Property Act. They have several states who've enacted it and others who are working on it. In Alabama, there are a few protections when it comes to heirs trying to resolve heirs property issues now. You know, there are protections such as notice of the partition action, fair market value, appraisal for fair market value, first right of refusal. So those are some protections that are added into the law. So depending on what state you're in, you know, you would have to look to see if your state recognizes the Uniform Partition of Heirs Property Act, and then you would have to find legal counsel that's competent and knows how to navigate that law to resolve heirs property issues. Summary is, heirs property can lead to land loss. Land loss is where my passion is at, so that is what I primarily focus on, is land loss. I want everybody to know that heirs property can be anything. I will never forget, my coworker has a beautiful gold chain that she's had for many years, and she wears, and she always discusses it in heirs property webinars and trainings and workshops. And she'll say, I don't know which one of my children are going to get this gold chain, but it's mine. It's my property. It's my asset. And so we have to think about heirs property as anything that we own, any asset that we own, if we do not give instructions. In fact, when I'm reviewing old wills, they would write down who would get the china. It was that specific. And so we need to think about heirs property as all of our assets. But heirs property can lead to land loss, limits the landowner's use and impact in the community. Death is inevitable, so do not be afraid to discuss it, and execute a plan to distribute your property according to your wishes. Estate plan is crucial for everyone to prevent further land loss. If you do not commit to transferring your property to kin or whomever, then the state will distribute it according to the state's intestacy laws. That is my presentation for the evening. And if we have any questions, do we have any questions?
And you know, I am battling with coming out of this. All right, let's see. I'm going to shut that down, and we're going to go back here. Okay. I apologize for the screw up of the presentation, but it is available. I think we can share it, included in the posting on our YouTube page. It will be available. So, are there any questions before I ask mine from our virtual audience? They're probably typing in. I have one. I heard you say the power of attorney.
Mm-hmm.
Um, what range does a power of attorney have?
What range?
How broad is their range? Um, as far as signature wise.
Okay. So I do not answer, I don't answer legal questions. So if you're interested in a power attorney, it would be best to sit down with consult with a licensed attorney and tell them why you are specifically considering that legal term, that legal document, and allow them to tell you what the power attorney is good for and how far reaching it is.
That's what
And
I
I
need
say,
to know. We did have a comment from Miss Barbara Dunn. She said, "Thanks. This is some good information." And for those who joined us after the beginning, what Miss Hutchinson was sharing with us is that, and it was summarized. We all, no matter how small it is, just as she was sharing about her friend with the gold chain, we have to put something in place. We need a will, estate planning. Um, oh no, ma'am. I probably didn't miss Mahaley. Um, Miss Tracy Halcrombie. I'm having to pull my phone because I can't see.
that's okay.
She says, I have done our wills and trust through online legal forms. Is it okay to do it that way, or should we have an attorney? The forms have been notarized.
My suggestion is to consult with a licensed attorney. At least that the licensed attorney review those documents and make sure that they are consistent with your state laws. I say that, and I'll give an example of what I mean. In Alabama, you can't disinherit a spouse. So if I go and I create an online will and I leave everything to my children, then my husband can challenge the will because I can't disinherit him in the state of Alabama. So that's a good example. You want to make sure that your documents comply with your state laws. You don't want to create a will or any other document and not not face the fact that it may become invalid. That's the best way to put it. It may
Okay.
be be able to be challenged. And another thing to note is to note that a will is, in my opinion, a running document. Anytime there's a major change, you need to review that will. If you've left something to two children and you happen to decide one day, that child is having problems or issues, and I don't trust that child anymore, you may need to go and redo your will to update it. Or if someone dies, you need to go and redo your will. If you get a divorce, you may have to do your will. So it's that anytime there are any major changes, you want to make sure that you update your will to reflect those changes in life.
Okay, now she said that was in the state of Georgia. So the advice that you were given, those, Alabama law, correct? So
Yes.
that's what she suggested for those residents of Alabama. So for those who do not live in Alabama, what do you suggest to them that have
Oh,
done the online wills?
no, it doesn't matter what state. I don't care what state you're from. Laws vary. And so if you use an online document, you need to clear the information through through an attorney, a licensed attorney in that state.
Okay.
You want to make sure that the information that you're using in that document is valid.
Okay. We have another question from Sharondelin. She says, do you have to file the will, power of attorney, and living will with the county if completed through online site, or it being notarized original, is that good?
Um, wills are filed after death. Is that what I think that's the question that she wants to know is it would be filed after death. The will would be filed after death.
Okay, what about the power of attorney? Do you need to file that as well? Or is that a legal question?
I would say because like we were talking earlier, it depends on that power of attorney. So that would be how it would depend on the verbiage, I guess. And so I would suggest running that by an attorney.
Okay. Are there any other questions? I I'm gonna ask this. So you were talking about a partition in kind and about if I'm in line. So there are four of us,
Mm-hmm.
and that would mean the land is partitioned between the four of us, correct?
Okay, so partition in kind would mean because you all own the property. You all have an interest in the entire piece of property. And so partition in kind means that the four of you sat down, you've talked, you've walked the property, and you've said, Norfonda, I've got this 2 acres over here. And my other siblings have 2 acres here and 2 acres. You have identified where you're okay with having your property. Then you'll have it surveyed. So you identify Norfonda's specific 2 acres. And then you get a deed that says, according to these boundaries, this is Norfonda's two acres of land. And so you can go to the court with 4 new deeds that identifies each individual person's property ownership. Okay, so you would divide the property up. Partition for sale is we cannot figure out where to draw the line. We can't get along. We're fussing, we're arguing, we can't come to an agreement. Okay, partition in kind is we can sit down, work this out, pay for our own survey, have the lines drawn, get our new deeds drawn up, and then we legally own our property individually.
Individually.
Is no longer one big piece. It's been cut up and divided into 4 pieces.
And that was going to be my question, because if all four of us, if it was not partition in kind, if all four of us, you know, own the land, and then so happened, if I did something with my portion of the land, would my other 3 siblings be responsible? Could I do that?
So if all of you still own it,
Yes.
you all still own the whole property. You can't say this mine, because the whole thing, that you can't just, y'all can't have nothing to do with this 2 acres because I'm claiming this 2 acres over here. No, you own the whole piece of property.
So if it's multiple siblings, do you suggest to do a partition in kind?
My thing is to sit down and have that family conversation and decide what's best.
Okay.
My family chose to do a LLC. That was their decision. So I can't specifically say what's best for a family. That family's gotta decide on that. The big thing is being able to sit down, have the conversation, and decide amongst your family what to do. That's a huge thing. Another big thing is deciding, as hard as it is to do, is if you have multiple children, sitting down and deciding who's going to get what. How can I divide my assets up fairly? Well, I may want to do a whole bunch for one kid while one kid's while I'm living, and then I may leave another kid the house and the land. That's the hard part. Because if you do a will, if I were to sit down and do a will, and I said I'm leaving it to my children in equal shares per stirpies, that I would create heirs property. They would have to fight over it. And we're talking about land, but let's just talk about a fur coat. I like to use the fur coat in the closet, okay?
So something as simple as a cell phone.
A cell phone. Who owns this phone? Okay, all four. Mama said she leaving her assets to all four of us. So that cell phone, that's why I break it down to small things, because, you know, with joint ownership of land is just like joint ownership of a fur coat or a cell phone. It's the same. It's the same thing. You have to identify, you know, who is going to take the fur coat. Or if we can't agree on who's going to take the fur coat, then we'll just sell the fur coat and split the money, because we can't decide on which person. So you have to look at land and the fur coat the same way.
Okay. So for those who just joined us, we were talking with Andrea Hutchison, paralegal. And we were talking about me and my estate, minding the assets. Very good information she has given us. She has broken it down to us. My question is to you, and I'm asking myself this aloud as well. Do you have your business together? Do you have a will? Don't think because you're, I'm going to say young, that you have time.
Right.
You don't. You don't. And if you have children, not a child, if you have children, if you don't have any children and you have sisters and brothers, you still need an estate planning, correct?
Estate plan, yes.
Okay. So I got one other question. So say for instance, I've done a will and I have 5 children. And I know you said if anything changes, we need to immediately change our will. And if one of the children so happen is deceased or they become incarcerated, and we've already given that portion of the property to them, but I'm deceased. So what happens to that other person's estate that been given to them?
Okay, so if you have 5 kids and you've left your estate to all 5 children, and then one of the children die, it depends on, that's another legal question, okay? But I can kind of give you an example
Okay.
to help you understand it. What if that person has a wife or a spouse, I shall say a spouse, because it could be a female. So if that person has a spouse or that person has children, then you would look at where does it go. So depending on state law and how your state law intestacy flows, then it may go to the spouse, or it may go down to the children, or it may go back and then the four siblings may divide it. So it just depends on the law and how the law works. Generally speaking, you'll look to see if there's a spouse and then children.
Okay.
Mhm.
I think that's all of my questions I had. Don't send me no bill now.
I will not, but I'm glad that you asked that question because it didn't lead into it, but I'll go ahead and open it. You have to look at blended families. You know, I'm one with a
Okay.
blended family. And so when you're looking at those situations, you have to look at a blended family situation and prepare for it. And that's just a fact of life. And it is just something that we have to deal with in this day and time. So if that person dies, and it goes to the wife, then you have a non-family member. That's a person who is not in the lineage. They married into the family. So if that person, that spouse, has children, okay, that are not by the person that died, okay. Are you following me on that?
Uh-huh.
Okay.
I got you.
So you have to realize that it's gonna flow down the non-members' family lineage then.
Mm.
So, so you have to, those are things that we need to start talking about and thinking about, is that even in blended families, is how do we do this and make it fair? How do we do this and make sure that, if I have children and you have children, if I go first, my children are going to be protected. If you go first, your children will be protected, because Alabama is one of those states that stepchildren, they don't have very much leg to stand on. And so you have to be mindful of that. So I brought that up because there's another reason why it's important to sit down with legal counsel and discuss. There are so many moving parts to estate planning. You have people that are married, they go in, they fill out documentation on a job, and they have life insurance policy or retirement. They'll put a spouse's name down. That spouse dies first and never go back and update their estate plan so that spouse is still left as the beneficiary on the retirement plan or the life insurance. So you've got to, that's the reason why I'm so passionate about this. I'm so passionate about this is because I want people to know that it's more about estate planning. No matter what you had, do not feel like that you are not worthy of an estate plan. Not just a will, but a full estate plan.
Well, I've got my information and now I've got to get my business in order. So, Andrea, tell us how, if someone wanted to, and y'all, she said she can't give legal advice, but if someone wanted to contact you, can you share that information?
Well, I'm paralegal at Greg Varner and Associates. Greg Varner and Associates.
Okay.
We have office in Chelsea, Alabama, and we have an office in Ashland, Alabama.
Okay. So, y'all, there's the information if you all choose to contact her. She's at Greg Varner. And I'm telling you, we've got to get our business in order. And I'm so glad you did share that about the blended families because I forgot about that. There are a lot of
Mhm.
people who don't have children, but they are in a marriage where the spouse does have children. Um,
Correct.
very good information. And I think we are in any other questions? Okay, I think not. And I think we're about to call it a night. Oh. What happens to if you don't have that in place? Can you lose it?
So, okay, so that's what, I guess that's my whole ordeal is that we need to start talking about it, and just having a roundtable discussion and start talking about estate planning. Because if you don't consult legal counsel and start learning all the moving parts of your estate plan, there is a possibility of loss. Yes, there is a possibility of loss. And I could go through multiple of examples of how um you can lose without realizing that you don't have a plan in place to protect your assets. Trust, we talked about trust and difference in wills and trust. That's another tool that sometimes people use when they're trying to protect property. They have a child that has substance abuse problems. They have a minor child that's disabled. And if something happens, who's going to take care of that minor child with the disability? And, so there are so many different moving parts to estate planning. So if you can attend any webinars, workshops, do research online, and seek legal assistance from a licensed attorney in your state. That's the best thing that you can possibly do.
That I forgot about that. That's good. So, we don't want to lose what we have.
Right.
And it's just simple, as she said, stated, webinar. Now, does Greg and Varner have a Facebook page that we could follow or?
Yes, we do. We have a Facebook page and I know in Alabama, some of our states, some of the extension offices are providing the heirs property on the community level, I believe is the name of it. In fact, JC is in the middle of a session right now through the extension office, but you would be able to see where she's conducting, I think it was like about 6 nights, once a week for about 6 weeks or something like that. But anyway, you can see where but yes, as much as you can learn, try to learn it.
I think you shared that with me. If you can you share that with me again? And for those who are on Facebook, I will put it on the Team Whip Facebook page so you can join this webinar. And it's free, correct?
It is free.
It is free, y'all. Take advantage of these free webinars. Um, that's one thing Team Whip is just trying to do. Things that we come across, not things, experiences or situations we come across, we try to share with the public on a free level, because we're learning as well as you are. So, Andrea, I thank you so very much for taking time out of your busy schedule on this Monday night. I know it's Monday Night Football and there are several other events going on. They are saying thank you very much. Very helpful information that you have given. Thank you once again. I share this. You all please get your families together. I know we don't like to talk about death, but it happens. But we want to be in place. We want to be in order when it does happen. We want to keep the family from feuding.
Mhm.
Want to keep them from hassling, trying to worry about this and that. Who's going to get this? Where does this go? Just it's simple to be proactive and take care of it prior to. Um,
And you can take small steps. You don't
small
have to
step.
do everything. You don't have to do everything all at one time. because estate planning it does cost money, but so does probate. Probate's not free either. And so, it is best to just, even if you have to do one step at a time, if you want to do your will and then do your living will of your and healthcare directive, just do one step at a time until you can get it all done. And then make sure you keep it updated. My next advice is we work in threes in our office. So in my case, my mom would get a copy, my husband would get a copy, and my oldest child would get a copy, or my best friend, somebody would have, so, but yeah, because, we will put stuff on the mattress and not tell anybody about it. We cannot do that with our will. We have to make sure at least one trustworthy person will make sure that it gets filed. So the county will know who to designate give our stuff to.
Well, ladies and gents, we thank you all for tuning in to our virtual audience. Andrea, thank you so very much. We've been coming at this topic for about a year now. We finally got it in, and it's befitting because next week is National Estate Planning Awareness Week in October. So you all, we've got a jump start to it. Let's start being more aware. And that's what Team Whip is about awareness, prevention. That's what we're trying to do, is prevent the hassle. So if it's not anything else, thank you all for joining us tonight. Stay tuned to our next Me and My. You never know what we're going to discuss. So next month is November. Follow us. TeamWhip2015.com is our website. Follow us on Facebook as well. Andrea, thank you. Thank you, Virtual. I hope y'all have a great week. And for those who have tuned in, don't forget we have our Health Fest on this Saturday at the Sportsplex. Hope to see y'all. Y'all have a great night. Thank you.